Counsel. Detective. Good morning, ladies and gentlemen of the jury. I'd like to begin by thanking you for your patience and attention. I know these bench conferences can be painful, and your attention is greatly, greatly appreciated. At the outset, I want to say again, and I want to acknowledge again, the grief that this tragedy has caused everyone, including the Moorman family. I'd like to acknowledge that. And I'd also say it's absolutely human and natural that we would want to find somebody, anybody, responsible. But ladies and gentlemen, I said this in voir dire, I said it in opening, and I'll say it again. There is truth to be had in this case. There is science, there are facts, there is proof, there is DNA. The truth is to be found in the evidence, and the evidence leads you to one conclusion. It's there, it's in the facts, it's in the proof, it's what we've heard, and the truth is Bradley Caraway is the passenger, he's not guilty. Now let's begin by looking at the instructions. And I want to go to one of the most important instructions of all, instruction number 6. This makes our country different than so many others. The law presumes a defendant to be innocent of a crime. The indictment shall not be considered as evidence or having any weight against him. You shall find the defendant not guilty, unless you're satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he's guilty, you shall find him not guilty. Ladies and gentlemen, that is proof beyond reasonable doubt. And if there's a reasonable doubt, you shall, not should, not may. If there's reasonable doubt, it's your sworn and solemn duty as jurors to find this man not guilty. That's the way it is today. That's the way it's been for 200 years. Hopefully, that'll be the way it is for another 200 years. If the government wants to take away your liberty and your freedom, then they have to prove their case beyond a reasonable doubt. And if there is a reasonable doubt, you shall find him not guilty. All right. Now, there was an assumption made in this case almost from the beginning. And the assumption is, because he's the guy and because it's his car, he must be the driver. That is the assumption. And that is the assumption the authorities made as soon as Officer Cruz took Bradley into custody. Detective Buford said, "There's our driver. I'm sure he was the driver." This is the early morning hours of August 6th. There hasn't been a test. There hasn't been anything to the crime lab. There really hasn't been an investigation. There's been nothing. I'm sure he was the driver. And that assumption was made before the crime lab, before testing, before anything. And that assumption has driven this case right from the start. And no amount of evidence, no amount of facts, no amount of proof could overcome that assumption. What has happened here is they've tried to change the facts. They've tried to change the evidence. They've tried to change the proof. They've tried to change their theories. They've tried everything in the world, but the one thing they haven't changed, that assumption. Let's start at Gerstl's. One might think, again, that because he's the guy, he'd be taking the lead and leading her out to the car. Look, this is so tragic. These are two young people. Obviously, they clicked at Gerstl's. They're both intoxicated, but it appears, every part of Gerstl's appears that she is taking the lead. Let's take a look. takes him out. There's nothing wrong with this. She's social. She's outgoing. These appear to be two good people who clicked at a bar. But there's nothing about this which would suggest that he's in charge. There's nothing about this that suggests anything except that this is at a bar, happens, I guess, 100 times a week or more, and they click, and she looks like she's in charge. She takes him by the hand and leads him out. Now, what's the next piece of evidence we see? One of the biggest pieces of evidence in this case, all right? Let's take a look at this next piece of evidence because it tells you volumes, tells you absolutely volumes. And what we've got is a single key in the ignition. Now, Ramon McGee, remember Mr. McGee, who we've known each other 30 years, tried multiple cases together? What does that key mean? You know, these people just met at the bar. You may might want to give your whole house keys to the person. So you take off one key, the ignition key, and give it to the person who's going to drive. What else does that mean? What else does that single key mean in the ignition? It means he took the key off the keychain, handed it to her, because for whatever reason, she was going to drive. There'd be absolutely no reason in the world for that one key to be in the ignition except that he gave it to her. There's no reason you take it off your key ring. There's no reason you do this and then put it in the ignition. There it is. There it is sitting in the ignition because he gave it to her to drive the vehicle. That's why there's one key in the ignition. So she could drive the car. And lo and behold, after the accident, that key is still in the ignition. That key is proof positive of innocence. They can't get around it. That key points one way. He's the passenger. That's what the key points to. But there's equally important things to know about this key. And that is this. They didn't collect it. Now they had to know about it. They went to the car. Detective Buford went to the car. Dr. Smock went to the car. They looked at the car. They had CSU take this photo. They knew about the key. Well, they're directing CSU to take the photo. So they knew about it. And in the hundreds of photos that they introduced in this case, I mean all kinds of photos of everything under the sun. Grass, roadway, marks, whatever. You know what photo they didn't give you? You know what photo they didn't introduce? You know what photo we had to introduce? That photo. They didn't give you that because they didn't want you to see it. They didn't give you that because they gave it to us in Discovery. I think they were hoping we missed it. They didn't give you this photo out of all these photos because they didn't want you to know and recognize that the key was in the ignition. And not only that, they never mentioned it to you. Detective Buford never mentioned it when they questioned him at all. Smock didn't mention it when he was on direct. It only came out when Mr. McGee cross-examined Detective Buford, and there it is. And when I asked Dr. Smock, I don't know anything about a key. Detective Buford, I don't know anything about a key. These are veterans. They've investigated many accidents. There it is. So, ladies and gentlemen, what do? You got a crime scene unit here. You have the crime scene unit take the gloves. and you collect the key, and you send it to the crime lab, and you test it. You test it for DNA. You test it for fingerprints. You swab it. You print it. You do whatever. Ladies and gentlemen, that's what you do. And we would submit that her prints or her DNA would be on it, and then that's the end of the case. They didn't test that because they didn't want to test it. They didn't test that because they were afraid of the results. They didn't test that because they don't trust their case. So they let it sit in the ignition. Got a murder charge, 20 to 50 to life. Crime that's an hour away. That key would have destroyed the assumption they made. That key would have absolutely destroyed it. So they didn't test it. Well, to support this assumption that they made immediately that morning, what proof did they offer you to support that assumption that he's the driver? Well, they brought in Dr. Smock. Now, Dr. Smock, ladies and gentlemen, is part, essentially, of the police department. He has the doctor by his name, but he's biased 95% of the time. He's testified for the prosecution hundreds of times. There he is in police gear. Police, Dr. Smock, testifying for the Commonwealth once again to supply whatever gaps are in the case, to supply whatever they need in the case. That is Dr. Smock. He is not a professor at UVL. He's not a treating physician. He is essentially a contract employee for the police department. He is biased. And within 3 days, he's written his email. Caraway's the driver. That email was August 9th. 1 day later. 1 day later, Brad's charged with murder. You think about that. Police, Dr. Smock, August 9th email, August 10th charge, murder in 4 days. And they haven't even gotten anything to the lab yet, and the charge is murder. All right. Now, what did Dr. Smock tell you? Let's try to break this down. All right. Dr. Smock tells you that he did this forensic exam of Bradley Caraway, and that he went and examined photos his forehead, and he found glass in the forehead, and then they extracted the glass, and he says, see, his head hit the windshield. That's how Caraway's blood got on the windshield. It's actually, they say the driver's side is actually to the right of the steering wheel. That's how his head got, that's how his blood got there, not through flailing his arms, which were cut, not through flailing his hands. It was a head strike to the interior front windshield, and there was abrasion on his head, and there's glass in the abrasion, which we extricated. This is what he swore to on the June, a hearing this year. He swore to Judge Smith the following. On the left side of his forehead, there was an abrasion. I'm not making this up. This is his quotes, word for word. On the left side of his forehead, there was an abrasion. And within that abrasion were small pieces of glass.
Judge, can we approach?
You may.
That's what he said, word for word. And that's what he admitted he said when he testified. All right? That's what he said. So, let's break it down. This is crucial pieces of evidence. Was there a head strike? And they didn't say the scalp. He said the forehead, but I don't see blood on the scalp either. All right? Well, let's start with the forehead. Do you see an abrasion on this forehead? Answer, no. Do you see blood on this forehead? Answer, no. Do you see, remember this is all recorded, Detective Buford recorded it all on his body cam. Do you see glass being taken out of an abrasion? No. That just didn't happen. It didn't happen. There's a piece of glass, I guess, on the head, but it's not even laminated glass from the windshield. It's safety glass. But we'll go back to the, if we can here. There it is, right there, right there. There is absolutely nothing. Now remember, proof is supposed to be proof beyond a reasonable doubt. That's what we're supposed to have. This is a key piece of evidence. This is how his head hit. This is proof his head hit the windshield. And you look here, and there's nothing. Then the forehead becomes the scalp, and there's still nothing. And then remember, the glass is coming from the abrasion. Do you recall the glass coming from the abrasion? That's what he said. And then he said he collected the glass. There was no glass to collect because there was no abrasion. And there was no glass in the abrasion. There was no glass to collect. This was supposedly the exhibit with the glass in it. This is what supposedly the glass was put in. This was supposedly what he combed out and then put the glass in here. Sonny Cease looked at it. Dr. Smock looked at it. Guess what? There's no glass. So when they tell you, well, we got glass from the forehead and it matched the windshield, and that's how his head struck the windshield, we know that. It's all untrue. It didn't happen. The cuts are in the hands, and that's how his hands flailing about. And the way they said it happened didn't happen. You think about that. No abrasion, no cut on the forehead, no injury to the forehead, and no glass. Look at it. It's admitted. They had you checked. They believe Smock. Let's keep going. Let's keep going on this case. Dr. Smock talks about these seatbelt marks. Ladies and gentlemen, these seatbelt marks are essentially cherry-picked. You can say anything's a seatbelt mark. Anything you want. If you want the facts to fit the conclusion, if you want to make the evidence fit, you just go with whatever. So you need his head to strike the glass, you say there's glass in his forehead. You need to say he's a driver, you say the seatbelt marks. Let's look at a couple of these seatbelt marks. That's Miss Moorman, but let's take a look at Bradley first. He's saying that's a seatbelt mark, okay? Of course, Sonny Cease said it wasn't. Sonny says that doesn't have any, he doesn't see that as a seatbelt mark at all. But then you've got a mark over here. Suddenly, on the right-hand side, that's not a seatbelt mark. You see, if the seatbelt mark's on the right side, guess what? He can't be the driver. So Smock is picking and choosing. We'll call one of these a seatbelt mark and not this a seatbelt mark. It's all a rabbit hole anyway, because let's look at how they did the forensic exam. Let's look at the start of that forensic exam. In the gurney. They immobilized him. EMS did that. They strapped him in. There's straps over both shoulders. He is strapped in beyond anything he would have by a seat belt. The whole point of that board is you can't move. And they got straps there over both shoulders. So they immobilize him. They put straps over his shoulders, which I understand. They take him to the hospital. Smock does his exam. He's not treating him. And all of a sudden, well, he's got strap marks on him. No kidding. Let's keep going if we want to keep going about these seat belts. Let's keep going on these seat belts. That he's picking one and not the other and forgetting about the immobilization and not mentioning that and the fact that he's strapped right before the... Let's keep going. Let's look at for a second, if we can, at Miss Moorman. You got a mark going leftward and down. You know what? There was a person who testified in this case who wasn't beholden to either side. That's the medical examiner. And let me just say about the medical examiner, we've got a medical examiner's office that's first rate, and they try to be unbiased. And they'll talk to you if you make an appointment. And you ask them questions, and they'll educate you if you want to know, if you want to find out, if you're interested in the truth. So we asked Dr. Springer, could that be a seatbelt mark on Miss Moorman? He said, could be from the accident, I think, but I can't rule it out. That's what the medical examiner testified. This could be a seatbelt mark, and if it is, she's the driver. That's the medical examiner because it's coming from the left side. Now remember, proof beyond a reasonable doubt. This is what their burden is. Their witness, their expert, medical examiner says that could be a seatbelt mark, and if it is, she's driving. And let's keep going. Let's keep going. They have a medical examiner here, all right? So what would be a logical question for the Commonwealth? Hey, let us show you some Dr. Smock pictures. See if you think Smock is right. See if you think those are seatbelt marks. They never showed him the marks on Bradley Caraway. No. And not only that, Dr. Smock never talked to the medical examiner, never showed him the pictures, never said, what do you think, never did any of that. Because we don't want to kill the assumption. We got an assumption here, and nothing is going to kill it nothing is going to make it die. That's the fact. Here we got left, right. You can't even say any of those are seatbelt marks. Then when she has one on the left, well, the medical examiner says it could be, and they says he can't even rule it out, which means she's the driver. It doesn't matter. It just doesn't matter. The assumption will never, ever, ever die. They may try to change the facts, as I said, the evidence, the proof, but they'll never change the assumption. And the best example I can think of is this. When my daughter was a teenager, she would watch these, for lack of a better word, horror movies. Okay, the monsters on Halloween. And one of them was named Freddy. Okay? And there was about 6 sequels. Okay? And I would sit through these movies. Okay? So I remember Freddy. And the thing about Freddy is he kept coming back. He would never die. No matter what happened with Freddy, he was back for the next sequel. And ladies and gentlemen, that's this assumption that he's the driver. It's never going to die, no matter what. All right, let's keep going here. Let's keep going. The medical examiner hasn't ruled out that she's got a driver's seatbelt mark. All right, there's straps all over them before they take the pictures. Sonny C said directly, none of these things look like seatbelt marks to him. So let's keep going as to what on earth that they've got. And remember, again, the standard of proof is proof beyond a reasonable doubt. And what did they do with Springer's testimony? Same thing they did with most of the evidence. They just ignored it. They just absolutely ignored it. The evidence isn't going to stop us. Whatever that assumption that wouldn't die, that assumption they made on the early morning hours of August 6th, never should have been made, but even being made, it should have collapsed. It should have been gone forever once the crime laboratory tests were in. Now, ladies and gentlemen, let's recall that this is supposed to be a search for the truth. Let's recall that they collected a lot of items. Let's recall that we're supposedly testing these items to see who was where. That's why we collected them. That's why they were taken to the crime lab. All right? Well, let's talk about the things they didn't test. Driver's side airbag, not tested. 2 swabs from the gear shift. Do you think maybe that would have been probative if Miss Moorman's hand had been on the gear shift? Not tested. Swabs from interior driver's side door handle. Not tested. There were 2 swabs from the driver's side windshield, which was actually to the right of the steering wheel, were tested, but 2 others weren't tested. 2 swabs from interior side. There was 1 airbag from passenger side door frame tested, but another airbag was not on the passenger side. And let's keep going. There was blood on a sun visor. If you can believe that. Passenger side sun visor, not tested. Are we trying to find the truth here, or are we trying to hide it? Glass fragments, not tested. Well, I can see why at least these weren't tested, because there are none. It says debris of glass fragments from suspect. No wonder they didn't test them. But my point is, ladies and gentlemen, look at what they didn't test. And I'll just talk from the passenger side sun visor. And I'll talk about another thing they didn't test. Swabs from the gear shift. We can't get evidence that'll kill the assumption. So these things just aren't tested. And let's listen, if we can, just for a second, to the crime lab person, Wendy Allman.
an expert in that. Because my job is, as a biologist, is I have to recommend what I think. So basically, even though I'm not a firearms expert, if I get biology for firearms, I have to preserve the evidence, and I have to know the sequence in which it has to go through fingerprinting versus firearms versus drugs versus biology, so that we keep the integrity of the evidence as it flows through. So before I even began, I asked the question of, could we place who was there based on the blood, because I didn't want to alter blood stains, and I was told that this case didn't qualify.
Maybe could we see that report?
It's not a report, it's a consult. It's in my narrative that I consulted with Bridget Holbrook.
Well, ma'am, here's the problem. Here's the problem. Did you consult with police who collected evidence? Did you do that? Did you consult with Detective Buford?
I make the decisions.
Did you consult with the...
Let me tell you why they didn't test all these items. There's a policy of 10. That's why. So we're going to stick to the policy. Carrollton bus crash, Sunny Seas had 161 items tested. And I don't care what the policy is. You know, and I have to feel, if someone says, look, we got to hold somebody responsible. And I understand that's a natural human feeling. But at the same time, what about the investigation here? Because I got a feeling that if these are powerful parties, if the defendant was the son of the governor, and the Miss Moorman was the daughter of the mayor, I submit to you, they'd test every bit of every single thing. But what they've thrown to us is anything's good enough. This is good enough for you. This is good enough for you. Bradley, you're looking at 2050. We're stopping at 10 because that's our policy. Let's not see who touched the gear shift. Let's not see whose blood was on the sun visor. Let's not see whose DNA is on the interior door handle. Let's not even look. We've done good enough. And let me tell you, we don't have our own crime lab. The defense doesn't. We don't have that. We're doing the best we can by being able to hire one expert. We don't have a serologist. We don't have a DNA expert. We have none of that. So you look at all this when they're trying to send them down, and you're looking at all this that they didn't test, and you're looking at all this that they didn't do. And then you're looking at that instruction, proof beyond a reasonable doubt. But let's keep going. Because at least we have a few results. At least we have a few results. There was blood. Passenger side airbag. Blood, passenger side airbag. Front. Bradley Caraway. Back. Bradley Caraway. Remember, the passenger side airbag deploys within milliseconds of the accident. And then glass is flying everywhere. His DNA is on the front. His DNA on the back. His blood's on the passenger side. You know why it's on the passenger side? Because he's the passenger. And it's a double whammy for the prosecution, a double whammy for the Commonwealth. Because just as it is Bradley's DNA, his blood on the passenger side, no blood belonging to Miss Moorman. None. This profile does not match. And that's different That is different, ladies and gentlemen, from the steering wheel. Remember, they made a big deal, well, his DNA's on the steering wheel. Well, yeah, it would be. It's his car. He's owned it for a couple of years. No. But they also said, as to the steering wheel, that there was a mixture. Remember, you can have what's called a major contributor. Bradley was, but there was a mixture, and there was at least 2 other people who touched that steering wheel. They didn't have enough to know. They couldn't test, but 2 other people had. So they can't say Miss Moorman's excluded from the steering wheel. But here, she is excluded from the blood test run by the State Police Crime Laboratory, which does testing for prosecutors all over the state, testing for this Commonwealth Attorney's Office, tested at the request of Detective Buford. It's not Bradley. It is Bradley Caraway. It is not Shanae Moorman's. So what are they left to argue? What are they left to argue? His blood, Bradley's blood, is on the passenger side, so he's the driver. Her blood is not on the passenger side, so she's the passenger. You think about that. They've taken reasonable doubt and stood it on his head. They have stood reasonable doubt on his head. His blood on the passenger side means he wasn't there, and her blood not being on the passenger side means she was there. And, please, the reason they tested the blood on the passenger side airbag, they were so sure of their assumption. It was going to prove Bradley was there. Can you imagine if the blood, it was going to prove Bradley was not there? They were sure it was going to be Moorman's. Can you imagine if the blood on the passenger side was Miss Moorman's? They'd be laughing at me, coming up with these theories. Well, this means there was movement. And they'd be laughing. No, they tested the blood because they sure the blood was going to be Miss Moorman's on the passenger side. It wasn't Miss Moorman's. It's not Miss Moorman's. It was Caraway's, and it was Caraway's because he was sitting in the passenger seat. Let's keep going. I'm just going to show this picture very briefly because I've got to. Miss Moorman had a head injury. She had a head wound, and there was blood on that wound. There was absolutely blood on that wound. There's him. There's her. Okay, you can take it down. The point is there's blood. So she'd been on the passenger side. Her blood would be on the passenger side airbag. That's why they did the test. How could you have bleeding like that and not on the passenger side airbag if she's in the passenger seat? How could you have blood on that and no transfer to the airbags, which deploy immediately? Whoever the passenger is in this case has blood on the airbag. That's why they tested it. That's why they did it. That's why they had the crime lab. And guess who's in the passenger seat? Guess who is in the passenger seat? This man right here. And that's why his blood's there. So, when they tell you his blood on the passenger side airbag means he's driving, and when they tell you that her blood not being on the passenger side means she's in the passenger seat, remember that. Proof beyond reasonable doubt. Don't stand and hold on his head. Don't let them essentially defy common sense. don't let them tell you things that aren't true. Don't let them tell you that A means Z. His blood, passenger side. Her blood, not passenger side. He's in the passenger seat. It's there because he was there. So what else do they have? What else do they possibly have in this case? Well, I guess they're going to put on these, confusing statements. Mr. Caraway made various statements. He was in an Uber, and an Uber driver got in his car, and he took a cab, and statements that don't make any sense. Please, let's recall, when police see him, he's wandering around. He's not hiding. He's walking on the interstate. You can't miss him. He has no shirt. None. When they turn the siren on, he walks to police, is what he does. This is a violent rollover collision. They're going to say, oh, this is his escape. See, he's covering up. It's a violent rollover. He's wandering around. He has no shirt. He's got no shoes. He's still, on the side of the road, not in the woods, walking along. And when the siren comes on, he walks. He walks to Officer Cruz. He's shocked. He's intoxicated. He's probably concussed. And what does he say? What does he say when Officer Cruz says, I'm taking you to custody? He says, hey, can I go home? Is this what we're going to do? Is this what we're going to hang the case on? The confused statements of a person who's likely concussed, who's intoxicated, shocked, been in a violent rollover collision? And let's keep going, because you got to go where the science takes you. But let's keep going. They said he didn't have a concussion. University Hospital never said any such thing. Never said any such thing. Never said any such thing. You can't do a CAT scan for a concussion. That's why these football players have concussions. They can't do a CAT scan. It's one of those things that you don't know. It's very hard to detect. But we know a couple of things for sure. We know that they didn't rule out loss of consciousness. They didn't rule out a head injury. They did not, despite what Dr. Smock said, they did not rule that out. And I even asked him and had the page of the medical records. I think it was page 30. And loss of consciousness, head injury, unknown. That's University Hospital. They didn't rule out a head injury. They didn't rule out loss of consciousness. EMS didn't do that. That's why they immobilized him. That's why they took him to the hospital. That's why they wanted him examined, because they thought he might be concussed. They thought he might have lost consciousness, and University Hospital never ruled it out. But there's something else here. If you recall, in the beginning, there was a charge of failure to render aid. And on failure to render aid,
Can we approach?
You may. right, ladies and gentlemen, the charge that I read to you at the beginning of the trial of failure to stop and render aid has been dismissed. Continue, Mr. Eggert.
Thank you. So what do they have left in this case? What do they have left in this case? Theories. Essentially theories that they've come up with at the last second. Theories that they've come up with after 7 years. Theories that they've had to come up with because the proof hasn't borne out their assumption. It's just one theory after another. One theory is, well, you know, it's a right rollover, so he must have gotten the blood on when he came over from the driver's side. There's no proof of that. None. None. They just say it. They just said it. Dr. Smock hasn't said it in a report. He didn't say it in August of 2018. He didn't say it in July 2018. He didn't say it in his email back in 2016. In 19, 20, 21, 22. He didn't say it. They're desperate to come up with a theory. Northrop's got this theory. Oh, yeah, but then they got another problem with that theory. How is her blood not on the airbag, passenger side? How is her blood not there if their theory is right? And that's all it is, a theory, because there's no proof, there's no evidence, there's no facts, there's nothing to support the theory. Absolutely nothing. They even attack their own expert. Poor Mr. Burroughs. When he looked, this car's been moved so many times, you can't even tell. It's moved from the scene, it's moved from its head, I understand that, to the other way around. It goes to the auto theft garage, back and forth. Who knows? But they even attack their own experts. Scott Burroughs said in 2016, the passenger seat belt was locked. That was a big problem for them, because if they're saying that Miss Moorman was in the passenger seat, they're saying, well, you know, you can't be ejected. So what did they do with Mr. Burroughs? They called him up 7 years later and said, do you think you might be wrong? And he's the guy they hired. He's the guy who came down and looked at it. When he looked at it, it looked locked to him. But the point is, we can't trust any part of their case, because they're even attacking their own experts. They're even attacking their own experts, and they haven't given you one bit of proof. I mean one. To support any of these new theories. Not one. Witness, well, I saw him get in the driver's seat. Or there was a trail of blood over the passenger side. Or her blood somehow was transferred. They haven't given you anything. And as for the shirt, who knows where the shirt was in the beginning, the shirt that they said blood on, because things were picked up, thrown out of the car, put back in the car. The crime scene wasn't preserved. You can't trust the case. You can't trust the scene. You can't trust what they've done. You can't trust anyone. And you can't trust these new theories, all of which have one goal: to justify the assumption that they made in the early morning hours of August 6th. He was presumed guilty. Recall I talked about reasonable doubt, and how in this case there was a sea of reasonable doubt. And really, it's an ocean. Blood being where it was, her blood not being where on the passenger side. Stuff not tested, stuff not collected. No glass, no wounds. Seatbelt marks, really, whatever you want to say them. Medical examiner. The list goes on and on and on and on. And you don't need 30 reasonable doubts on a case to find a man not guilty, or 20 reasonable doubts, or 10 reasonable doubts. One reasonable doubt on the whole case, the man's not guilty, and this is nothing but reasonable doubt. So if we stopped and didn't put on one shred of evidence, the verdict's not guilty. Now, we did put on Sonny Cease. Let's say you didn't like Sonny. Let's say you rejected everything he's got to say. The verdict's still not guilty. They didn't prove their case. It's one reasonable doubt after another, after another, after another. But what did Mr. Cease say? First of all, he's a real expert. He's not publishing articles. He's not lecturing. This guy started accident reconstruction for the state police. They said his company's in bad standing. I don't know what they're saying that's for, not paying some fee or something. Come on. This man started it. He investigated just accident after accident after accident. He trained. He did the protocol. He did it around the state. He did the Carroll Road crash. You can't get a more knowledgeable expert than Sonny Cease. And his career, 22 years for state police. And if I just say something very quickly, you know, we've challenged the investigation in this case, which we do. We've challenged it hard, but we are not unmindful of some of the things those first responders and police officers did that day. You listen to Tommy Woods trying to find out who's in the car, that EMS guy who came out in the early morning hours and, you know, they try to revive her and they do CPR. You know, we should be grateful, and we are grateful to them. But this investigation, they're not part of the investigation. This investigation failed. It failed. It absolutely failed. And I suspect, ladies and gentlemen, that those EMS guys and those police officers who came out at 3 in the morning to answer those calls, do you think if they got a call an hour later at 4 a.m., do you think they said, sorry, we've done our 10 calls for the day? I don't think so. They'd have answered. They'd have answered the calls, however many there were. So, Sonny's an expert. He's been doing this forever. And what does he say? First, seat belts. He says, you can't just look at a seat belt and say, oh, it was just on. That's unreal. That's just making up things. He says that looks like ordinary wear and tear. He says none of the seatbelt marks. He could have said that hers is a seatbelt mark, but he said, no, none of these are classic seatbelt marks. And he told you that. Out of the gate, he told you that. And if I don't know who's a NASCAR fan, but those guys really are cinched in, okay? Nobody here appears to have been cinched in. Nobody appears to be cinched in. He says absolutely not a seatbelt mark, and that a classic seatbelt mark. And remember Springer, what she had could be a seatbelt mark. He also said, and they attacked him for this, that there's no way, once the pretensioner fires, there's no way, okay, that you can come out of the seatbelt. That's just wrong. Let's listen, not to Sonny Cease, let's listen to one of their own experts.
Power on the inside. Yes, for a rollover. Yes, it's a tube. Okay, and you had mentioned something about an occupant might strike that roll tube. Is that correct? Yes. And this is in the event of a rollover? In the event of a rollover, we can do it. Yes, sir. And in your testimony, you made the statement, you said the occupant may hit it whether they're strapped in or not. Yes. Okay, well, maybe you can help us here. If the pretensioner fires and locks you back into the seat, and its goal is to keep you in the seat, in position, and that includes both the lap belt and presumably the shoulder restraint, correct? Correct. Are you saying that the occupant can still move up and down the vehicle?
especially in this case, the roll offender from when it was identified was 2 seconds long.
Yes, sir.
And even after you get the benefit of, say, the pretension to hold you in,
Yes, sir.
with the roll rate being 299 degrees per second, it's not like a washing machine. You're on the spin cycle inside the car. You could slide out of the seatbelt or not be belted and put your head up.
It's been an hour, Mr. Eggert.
Thank you. Thank you, Judge.
You could come out of the seatbelt. That's what he said. That's exactly what he said. And that's their expert. That's North.
That's their expert. He said exactly what Sonny Cease said. They attacked Sonny when he said it, but Sonny was telling the truth. In this particular roller, you could slide out of the seatbelt. And he came down from Rochester, New York, was paid well by the Commonwealth, paid by the prosecution. In this particular rollover, you could slide out of the seatbelt. When Sonny says it, well, Buford says, no, never heard of that. But when Northrop, their expert, says it, well, there it is, in black and white. Yes, in a rollover like this, you can go out of the seatbelt. All right, now let's take what Sonny said, because what Sonny says makes sense. He says, when car, right frontal, collision, it's the embankment, there's a roll. There's at least 2 rolls. It's a rollover collision. The car travels 500 plus feet, okay? 500 plus feet.
Ladies and gentlemen, Miss Moorman unfortunately had to be with a car almost to the end. Otherwise, the car can't have landed
On her. She can't get out at 200. She couldn't have been thrown out at 200, 300 feet, because otherwise she wouldn't have ended up under the car. She's in the car almost to the end. All right? Now, once the car crashes, let's take a look at the vehicle. You can't get out of this vehicle once it's crashed. Okay? You cannot. You can't get out the driver's side. I think they have to force the doors open. Okay? You just can't get out the driver's side. Officer Wood smashed open one window and the other doors. You can't get out the driver's side. Let's keep going. All right. Windshield. All right. No way you can get out of through the windshield, and you'd be cut to smithereens anyway. You'd be diced. You can't get out the windshield. Let's keep going. Passenger side. You can't get out the passenger side. All right? You know, it's blocked, and the angle of the car is such that there's no way you can exit the vehicle. You can't get out once this thing crashes. You can't. Look at these pictures. All right? And maybe they say the rear deck window, but the problem with that is Sonny Cease measured it. 9 by 14 inches, a human being can't get out. Which means once the car crashes, you cannot get out. So, she's still with the car almost to the end. That's how she ends up under it. He cannot be the driver. Because if he was the driver, he can't get out after it crashes. See that? He cannot. And that's what Sonny was explaining. If he's the driver, there's no way to get out. Now remember, it's blood on the passenger side airbag. So suppose they say, well, okay, but suppose he got out before the end. How's he supposed to get out? If she's in the passenger seat, he'd have to go through her, over her. It's impossible. And somehow in this scenario,
his blood would end up on the passenger side, even though he was on the driver, and her blood wouldn't be anywhere on the passenger, even though she's on the passenger side.
It can't be done.
When this car crashes, he's already been ejected from the passenger side, just like Northrop said you could.
That's what happened. That's the only thing that could have happened. She's got to be in the car to the end, almost to the end, the last rollover, and he cannot get out of that car once it crashes. And if she was in the passenger seat, he couldn't have gotten out at all.